I'll skip that. Manoj, please see 166. The governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I earnestly request your Lord.
But we are, since we are on those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there'd be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that this 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the House? Prima facie, at least, for him.
Now, let me show the judgment of the High Court, which was dealt with by Bommai judgment. Your Lordship's, my Lord, very right concern, my Lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your Lordship in Bommai did not accept that rejection. Kindly, my Lord, allow me to place, my Lord, that High Court judgment, my Lord. Because when we cite Bommai, my Lord, we generally don't see the High Court judgment, my Lord. Kindly see, my Lord, para 32. And this would be, my Lord, an answer. And, my Lord, please, again, my Lord, I am requesting, please examine the law as agnostic of the facts right now. And thereafter, my Lord, I will assist your Lordship on the facts. What is the law? What is the power of the governor? What are the contours of power? What are the limitations? Lord, please come to para 32 at 2472, my Lord. The right-hand side top is the pagination.
1 minute.
2472, my Lord, para 32. So this can be, my Lord, my answer.
Para 32.
32, my Lord, at page 2472 of this judgment. Lord, left or right-hand side top, my Lord, is pagination. May I read, my Lord? Your Lordships have got. Mr. Soli Sorabji also contended, this is his argument before the High Court, my Lord, that the factors like alleged unethical methods adopted during the formation of Janata Dal, expansion of cabinet, horse trading, and atmosphere getting vitiated are not only vague but have no rational nexus at all. The question of failure of constitutional machinery, the learned counsel also laid, my Lord, kindly come down, my Lord. Anti-defection law, my Lord, it says, I'll just read fully. The learned counsel also laid great stress by contending that governor, by acting upon the letters given by 19 legislators, had circumvented the anti-defection legislation, the primary aim of which is to discourage the toppling game by legislators by changing their loyalties, and by acting upon those letters, the legislators were permitted, in substance, to play the game of toppling the ruling party, ruling ministry, without incurring the consequence of anti-defection law, because if these legislators had withdrawn their support in the House and voted against the ministry, they would have incurred disqualification under anti-defection law. Reliance upon these letters is contrary to the underlying purpose and the essence of anti-defection legislation, and therefore illegitimate and prohibited. Kindly mark this. The learned counsel buttressed these arguments by contending that if the floor test had been held, the legislators would have written letters, who had written letters might have changed their mind for several valid reasons, i.e., change of the style of functioning of leadership, change in the leadership, realization for maintaining party unity, unwillingness to incur disqualification under anti-defection legislation, and 5, not giving a pretext for imposition of precedence rule. In support of the contention that the floor test has always been recognized as the legitimate and relevant method, Sri Sorabji relied on the judgment of Orissa High Court, so and so, so and so. Lord, he was insisting that please allow floor test, because that's what the law says is the only test. That's what we call dance of democracy, is on the floor of the house, not outside. And the governor cannot go beyond a particular point. Lord, this was rejected by the High Court, my Lord, at para 54. 34. Page 2475. May I read, my lords? Mr. Sole Sorabji had made pointed reference to the 10th schedule, that is anti-defection law, for bringing home this point, that the factum of the withdrawal of support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in
34.
I'm sorry, my lord, page 2475, para 34. I'll read again, my lord, for my Lord Justice assistance. Mr. Sorabji had made pointed reference, this is the finding of the High Court, pointed reference to the 10th schedule, i.e. anti-defection law, for the bringing home his point that factum of withdrawal of the support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in the context of anti-defection legislation, floor test was the most relevant, legitimate and surest method to determine whether the Council of Ministers headed by Sri Bommai commanded the majority in the House or not. We are afraid we are unable to agree with this submission of the Learned Council. The introduction of 10th schedule in the Constitution has not in any way affected the exercise of powers under Article 356, nor has it amended Article 356 in any manner. The amending body which inserted the 10th schedule to the Constitution had before it the several decisions, especially the Rajasthan case as to the scope of Article 356. There is a presumption that the lawmaking body was aware of the existing interpretation, and the court said that no, he should have kept Schedule 10 in mind while exercising powers under 356. Now, my lord, please see how Bommai judgment deals with this. Lord, it was pointed out that para 397, my lord, was read out of context, my lord, to show. Lord, kindly see, Lord, Bommai is, my lord, JC volume 2, PDF page 516. Yes, my lord. Your lordships, my lord, in the judgment of Justice Jivan Reddy, my lord, at page 516, my lord, para 389, formulates the question. Volume 2. I'm sorry, my lord, my allotted time is over, my lord. Kindly allow me, my lord. I am not repeating anything, my lord. And
certainly.
The 389, my lord, your lordship says, I'm not reading all questions because they are not relevant for the present. Only question number 6. A special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that, all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my lord, the court, my lord, thereafter records, my lord, page, my lord, 393, my lord. I'm sorry, my lord, 3. No, 397. In this context, my lord, the court examined this, my lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. And that in that context, my lord, 397. Please see, my lord, 397. May I read? We are equally of the opinion that High Court was in error in holding that enactment or addition of 10th schedule to the Constitution has not made difference. The object of 10th schedule is to prevent and discourage floor crossing and defections, which at one time assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in case of split, a legislator had to support his party willy-nilly. This is the difference between the position obtaining prior to and after 10th schedule. Prior to the said amendment, the legislator could shift the loyalty from one party to the other any number of times without imperiling his membership of the House. It was as if he had property in the office. That, my lord, in that context, the request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. Take step under 174 and 175. That's what precisely the governor has done. And, my lord, a similar situation arose. And, my lord, now I will read your lordship's the judgment in Shivraj Singh Chauhan, where all this is considered. But before that, please come to para 7 of my propositions. There are more than one reasons, my lord. Why, my lord, this cannot be the argument of the petitioner, and I'll demonstrate, my lord, what is the flip side of this argument. If your lordships, my lord, were to hold that governor cannot examine the inter se dispute, or he waits till the speaker decides disqualification, what is the flip side? I must, my lord, assist your lordship with that flip side. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing floor test, since it is possible that the original political party of the members of the House may condone the defiance of the whip as contemplated under para 21B of the 10th schedule. Lord, kindly pause here for a minute. Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction. The government has lost majority. There are attacks taking place. There is vandalism taking place, threats being administered. Then I'll not wait for 15 days. Because party may.
Mr. Solicitor, there are two
distinct examining propositions.
Right, there are two distinct things. One is a dissatisfaction within a party, right? And the other is the loss of majority of the government. One is not necessarily indicative of the other.
Correct.
Now tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, only one thing. Kindly bear one.
Only one 34.
Who were part of the government, who were supposed to be having confidence of the chief minister.
Right. So
Therefore,
now let's go to the bottom of it.
Look, can I first take the lordships to the bottom?
What is the governor saying? These 34 who are part of the Shiv Sena have now expressed their dissatisfaction with the leadership of the Shiv Sena. Unless the governor says that the natural corollary is that these 34 will cease to support the Shiv Sena.
I'm sorry.
Sorry.
It's not even that.
Not even that. We will make every assumption in favor of the governor's decision. Because that's how we test the proposition. What could the governor have said, though he doesn't say that these 34 persons who are part of the alliance between the Sena, the Congress and the NCP have now expressed their dissatisfaction. He can call for a floor test if he has any circumstances before him to indicate that the strength of this three-party coalition has been substantially reduced. The Bommai is absolutely correct, it binds us anyway, that this disqualification issue under the 10th schedule is completely irrelevant. But what is the consequence? The governor has to treat these as continuing members of the Shiv Sena. Even before us, they are not saying that we have ceased to be members of Shiv Sena.
Yes.
Now, if they continue to be members of the Shiv Sena, and the Shiv Sena therefore continues to have 55 or 56 members, which it originally had.
If they vote against, they will incur disqualification. Governor would say that.
Right. But then where is the question? What is the reason for calling a trust vote?
Because they said
The
that
governor, all our judgments say, Rameshwar Prasad says that, Bommai says that the 10th schedule disqualification is irrelevant to the exercise of judgment by the governor.
I'm obliged.
That authority
That's
goes
all
to the speaker. Therefore, the facts as they stand before the governor indicate that these 34 are part of the group of 56 Shiv Sena MLAs. Now, if that is so, on what cogent material does the governor call for a floor test? What has changed for him to call for a floor test?
Difficulty is,
Tell us one reason why he has to call for a floor test then.
my lord, your lordships are again on facts, my lord. I'm on propositions first. And then, my lord, I'll try and fit into the propositions to the facts of the case. Number one. Number two, principally.
Forget the facts. Forget the facts.
Principally.
Forget the facts.
What?
The governor, as a matter of principle now, Bommai tells us and Rameshwar Prasad tells us that circumstances which would lead to the which would warrant the invocation of the 10th schedule are alien to the mind of the governor when he calls for a floor test.
Correct.
All right. So, therefore, the possibility that these 34 in our case would incur a disqualification is irrelevant to the exercise of power by the governor.
Bow down, my lords.
Right? Now, if that is so, then the governor must forget the facts of this case, the prime principle. The governor must proceed on the basis of the position as it obtains. When the government has been formed, there is nothing which has, unless there is something, some subsequent event which alters the legal constitution of the government, the governor must continue to have before him and analyze the situation on the basis of the situation as it was when the government was formed and prior to the 21st of June in our case. He can't go into the 10th schedule, that's the speaker's jurisdiction. If he can't go into the speaker's jurisdiction, which is the 10th schedule, then what is the basis for calling a floor test? The only reason why he could have called for a floor test is that these 34 numbers, these 34 have alienated themselves. They have given up. They say that we have lost faith in Uddhav Thackeray, and therefore these 34 are excluded, the numbers.
But there also, Mr. Solicitor, there's one difficulty for them, and we are only looking at the material that is available for the governor to draw an inference that floor test is necessary. We are not about the facts of the case. Three factors you have indicated. One is the 21st of June letter. Second is the case of threats. Third is about BJP's, and fourth is about the independence letters. Those two, if we eschew from consideration, because from the opposition side, for him to base his decision, apart from threats, which is purely a law and order situation, what is remaining is the 25th,
it's not 21st a law.
Of June, 21st of June 2022 letter. That letter merely informs the governor that we reaffirm that Shinde to be appointed and continues to be appointed as the leader of the house. Number one. Number two, Gogawale will be the whip. You continue to recognize that. Nothing more than that.
Then-
It
then-
doesn't say anything more than
allow
that letter.
Allow me to, my lord,
So
answer.
now where does he draw an inference on the basis of this letter,
Yes.
which will become part of the material for him to take consideration?
Lord, please come to, my lord, page 14 of the material, my lord, which I have placed on record, my lord. It's not just a letter, it is coupled with
Yeah, we've seen that.
That
a
letter.
resolution. Coupled with a resolution. And, my lord, kindly bear
Resolution
one
of the 34, right?
34, my lord. It's not read before your lordship. Lord,
Okay, just
Yeah.
1 second. Let's go to that.
it's a PDF page 14, my lord.
That is at
401.
14.
list of LOD of the governor, no? That's what.
LOD of the governor. Yes.
Yes.
No, that's what I was referring to, correct.
That's not what page?
14.
Page
14.
14.
Yes, 14. That letter, the resolution.
Right.
We, your lordship, sir.
Just see 17.
Yeah. 17.
The following members of the 14th Maharashtra Legislative Assembly belonging to Shiv Sena. We are notified as the members of Maharashtra Legislative Assembly as members of so-and-so. We had unanimously elected Mr. Shinde on so-and-so as group leader. There was pre-poll alliance between Bharatiya Janata Party and Shiv Sena Party. There has been great dissatisfaction prevalent amongst the members of our party, that is Shiv Sena and our party cadre at large, on account of corruption in the government. Why this 3 years cohabitation and then, my lord, an attempt for divorce, using, my lord, that expression. Administration regarding police posting, corruption by the then Home Minister Shri so-and-so and sitting Minister Shri so-and-so, who is also in jail for involvement with underworld Don Dawood. Apart from above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds from the opposition ideological parties who are not now a part of the government and were using their office and power to undermine the base and foundation of our Shiv Sena cadre. This is their reason. I am not justifying, nor can I put myself into the shoes of the governor. And with profound respect, your lordships would also examine not what your lordships would have decided with these facts, but whether there
No, but
exists.
what the governor can constitutionally decide. We are not going to go into whether what our view is the situation is.
Kindly allow me to complete the sentence.
Constitutional duty and power of the governor. In
My
the
lord,
situation.
can I only complete the sentence?
And see page 17 now, PDF page 17.
My lord,
Hence, it
Lord,
is
kindly
unanimously,
allow
the
me to
end of
read.
it, what do they
15.
say?
My lord, I'm on 15. Can you allow me to
15,
read
yes.
15 also? This is enormous discontent. There is enormous discontent amongst the cadre of our party, that is Shiv Sena, for forming the government with NCP and Indian National Congress, who are ideologically opposed to our party, that is Shiv Sena. Initially, they say that they are destroying our cadre base. They are corrupt, found to be corrupt in near past. We are facing embarrassment. Then they say there had been a compromise on the principles of our party, Shiv Sena, which had been a party with fierce ideological base and was formed for fighting of the rights of local Marathi people. For last 2.5 years, our party and its leadership has compromised party principles by aligning with the contrasting ideologies for the sake of achieving power in the state of Maharashtra. The ideology of our party's leader, late Shri Balasaheb Thackeray, was to give clean and honest government to the people of Maharashtra, and also without compromising on the principle of so-and-so, which was defeated at the first day itself by aligning with the opposition ideologies. Shiv Sena and Bharatiya Janata Party had forged a pre-poll alliance for 2019 Maharashtra Assembly elections. They sought the blessings of voters for this Shiv Sena BJP alliance, which the voters accepted and voted in favor of this alliance. After the results were out, the Sena severed its ties with BJP and formed an alliance with opposing parties which they fought against in the 2019 Assembly elections. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre at large. As an elected member, I am answerable first to my voters, then to anybody else, my lord. Because 39 members can say that we will vote against the party even at the cost of being disqualified and ceasing to be MLAs. Then the governor is faced with a situation where there would be unstable government which cannot withstand on its
Which means he's going to the disqualification issue.
No,
potentially.
I'm sorry.
That's the problem.
That 39.
Right. All that you are reading up to PDF page 17, where they passed the resolution. The resolution is at page 17. Huh? There are two parts of this letter, two parts of the resolution. First part is, let's formulate it. One, the first part is BJP and Sena had a pre-poll alliance. One. In breach of the pre-poll alliance, the Shiv Sena teamed up with the Indian National Congress and the NCP. Two. Three, by teaming up with the NCP and the Indian National Congress, the Shiv Sena has militated against the core ideology of the Shiv Sena. Four, that there has been corruption in the government, and five, that there is discontent within the cadre of the party. This by itself will not justify the governor in calling a trust vote. Never. That's what our judgments have repeatedly said.
No, your lordships have said otherwise in Shivraj Singh Chauhan.
The fact that the conduct of a government has gone against the core ideology of that party can never call for a trust vote.
But I'm sorry.
Now, what then is in that letter? What then comes in the resolution? Two things. That we reaffirm that Eknath Sambhajirao Shinde, who was elected as the leader of the party, continues to be the leader. And two, that that we reaffirm that Gogole is elected as the chief whip. Two things. The first part of the resolution has no bearing on a trust vote at all. The first part of it only reflects on the fact that there's grave disquiet among these people that, well, you militated against our pre-poll alliance and the core ideology of the Shiv Sena. That's alien to the governor because they've formed government already. Second, what do? They merely reiterate that Eknath Shinde continues to be the leader of the party in the legislative party. How is this a justification for a trust vote?
I'll just
Change in the chief
answer
whip.
that question. Well, kindly come to page 21. PDF page 21. This is signed by 41 MLAs. My lord, the difficulty is, my lord, we are trying to examine and analyze the justification given by 34 or 39, whether it could have been a justification for floor test. For governor, he has to only examine that, but for this 39, the government would fall. I would rather go for the floor test.
In which case, he is now saying, assuming. No,
They are
but you're
part of the
right.
company.
You're absolutely right. You're spot on. There's no difficulty about it at all. Therefore, what the governor is saying is, but for these 39, as you rightly say, the government will fall. Can he look into the fact that but for these 39, the government will fall when exclusion of these 39 is postulated on the speaker passing an order for their disqualification under the 10th schedule. Until that order is passed, he cannot presume that they are going to be.
He is not.
It's a preemptory move.
Lord, I think we are.
To say that we remain part of that.
Correct.
government.
Exactly.
We are not parting company.
My lords are saying the same. My lords.
They say that we continue to be in the Shiv Sena.
Correct, my lord. But still, we don't
They
support the
continue to
government.
be in the Shiv Sena. Then how do you call for a trust vote?
Or what is the apprehension
Lord,
that the government
trust
has?
vote is not against Shiv Sena. Trust vote is against the government, against the chief minister. Correct. Lord, suppose what happens if the leader loses the confidence while members remain. Lord, now kindly see, my lord, kindly see the flip side of this. Flip side is this. Lord, today there is a government of Shiv Sena and BJP. Now your lordships, my lord, prima facie view is that merely because some people go and say that we don't trust this government, governor should not do anything, not that cannot do anything. Your lordship's prima facie view is, this is debate, my lord. I hope this is not the conclusion. Your lordships are only
In a dialogue.
Yes, it's a dialogue. Now, suppose today BJP has what, 106 members. Lord, 100 members were to say that we have lost faith in the leader. Even our chief minister, kindly allow.
Right.
Okay, kindly allow me to.
So 106 say we have lost faith in Fadnavis. Okay.
Kindly,
He was a
allow
leader.
me to.
For a moment, postulate it. Yes, you're right. Absolutely. Exactly. You're absolutely on spot on.
Kindly see, my lord. Would your lordships consider giving governor the power to wait for the floor test and ensure that there is some management where the majority is created? That's the flip side of it.
Mr. Solicitor, you can never allow the governor to ask for a trust vote when there is absolutely nothing to shake the majority on the floor of the House. What is the trust vote for? Do you have the numbers in the House? The trust vote is not for determining who is going to be your leader in the House. No. The trust vote, what is the purpose of the trust vote? In a House of 288, do you have 144? That's the purpose. And if there is nothing to indicate that 144 is disturbed, who will lead those 144 is alien to the governor. It may not have been Uddhav Thackeray. They could have elected somebody else. The INC, NCP, and the Sena would have said, "Oh, they're electing somebody else."
Would your lordships come to page 21? There is a
But
direct.
that is a matter of internal party discipline. You see, that can never be a matter for the governor. Governor's trust vote is where the majority in the House is shaken. And where was there anything to indicate that this...
Page 21. Page 21.
Yes,
Yes.
page 21.
Page 21.
Yeah.
This is
see,
47 MLAs writing to the governor on 25th of June, para 2.
25th of?
As is common knowledge, we no longer wanted to be a part of the corrupt MVA government. However, we were being continuously threatened to continue supporting the incumbent government without our free will. Thus, left with no option, we were constrained to flee away, said so and so. However, as yet another attempt to break out our resolve and arm twist us to give in to the demands of MVA government comprising NCP and INC goons, security which was earlier provided, etc. They say, we don't wish to support this government, meaning...
no, Mr. Mehta, if you will look at para 11, that's the conclusion. We demand security. That's all. They don't say we are parting company. Where do they say that? They say, please give us adequate security as also our family because it's been withdrawn.
The governor is not, my lord, a court where this prayer was not couched in this manner. He has to, based upon the material before him, arrive.
Mr. Mehta, what is being pointed out? What is being pointed out is this communication cannot be said to be withdrawing the support to Mr. Uddhav Thackeray. This is that what happened earlier, what happened that...
What it says, it may say that give us protection, but they say we no longer want to be a part of this corrupt government. Meaning thereby 47 people are minus now
they
from the magical mark.
What is being pointed out, then thereafter they don't say further that henceforth, correct, we are not supporting this.
If it is a petition, there is no prayer.
For the subjective satisfaction.
What's the next step they took after they said we are no longer want to be part of the corrupt government?
All right, you can just reflect on it.